We are back live.
And I would like to move that the committee come out of executive session.
I'll second.
All those in favor?
Aye.
Aye. Any opposed? The ayes have it. We are magically out of executive session. I always pretend I have a magic wand for these things. So again, I want to welcome everyone and introduce myself. I am Representative Angela Arsenault from Williston, serve on House Judiciary. And I'd like to take us around the table for a quick round of introductions, starting with Representative Casey.
Hello, folks. I'm Connor Casey here from Montpelier.
I'm Oliver. I serve Swanton and Sheldon.
Senator Brian Collmore, representing the Rutland County District.
Hi, Senator Martine LaRoque-Ulick. I live in Burlington and represent Winooski, Burlington, Essex, and Colchester.
Senator Terry Williams, also representing Rutland District.
Alicia Millay, represent Pittsburgh and Proctor.
Senator Ruth Hardy from the Addison District.
Right, and I want to just give a very short overview. I know some of you are probably very familiar with how this works, but for folks watching and for anyone who doesn't know how this tends to work, we will invite each judge up to our warm seat, a seat at the table to share with us a 10-minute introduction statement, if it can be. We want to respect everybody's time and also honor, the gravity of the situation. So if it can be somewhere around 10 minutes, we think that works well for most folks. And then we'll just go around the table. Each of us will have an opportunity to ask any follow-up questions. And then that's pretty much it. So I understand tonight we'll be and I'm sorry, I have to swear you all in. If we can do this all at once, you can each all stand up. What did I do with the language? Oh, I know. Little piece of paper. All right. Do you, raising your right hand, do you solemnly swear or affirm, subject to the pains and penalties of perjury, that your testimony shall be the truth, the whole truth, and nothing but the truth? Thank you. All right, so we will begin this evening with Judge Malone.
Angela, can I just interrupt? Do we need to amend the agenda then to do, because that's not the order on the agenda?
Oh, that's a good point.
Is it okay?
Yeah.
She's last if we're going to move her up. I just didn't know.
If I need to go last, that's okay.
So it sounds like we can modify the agenda. If there's, it would take perhaps not subject to a vote. Not that I've ever subjected adjustments to a vote, but okay. We will start with Judge Malone.
I appreciate you taking me out of order. And I intend to depart soon, but I have a 2-hour drive home. And if the weather gets bad, I have court and vettings tomorrow. I'd rather not be stranded there. So maybe. And so, good evening. I'd like to thank members of the committee for taking the time to consider my request for retention. I look forward to addressing your questions and concerns and hearing any feedback or suggestions you would like to offer as to how I can better serve our community. I don't think any of my colleagues envy those of us who are going through this process 2 years into our appointments. And perhaps somewhat ironically, it coincides with the benchmark that was universally identified by every judge I've seen, that their first 2 years on the bench were by far the most difficult, meaning that this process so far has been a timely experience in reflection. Certainly, I have found the past 2 years to be challenging beyond any other time in my career. And as I pass the 2-year anniversary of my first day on the bench, I recognize how far I have come and how far I have to go. Courtroom decorum means I rarely know how litigants and attorneys view my work. This has been a welcome opportunity to learn more about what I'm doing well, where I've improved, and what I need to continue to work. My background is solely in criminal law and juvenile law. I spent the first decade of my career as a staff attorney with the Public Defender's Office in Chittenden County, representing defendants in criminal proceedings and children and caregivers in abuse and neglect, truancy, and delinquency proceedings. At all times, I carried a large caseload and a busy calendar of court hearings. Every client offered a new challenge to help an individual achieve the best outcome possible for their unique circumstances. After 10 years with the Defender General, I was appointed by Chief Superior Judge Grierson as a judicial master in the abuse and neglect dockets in Chittenden and Franklin counties. I sat on uncontested juvenile matters and presided in the Chittenden County Family Treatment Docket. I brought to this role years of experience representing individuals struggling with substance use and helping them navigate the criminal and juvenile dependency systems. The experience of leading a team in a unified effort to support caregivers in addressing their substance use and its underlying causes, while improving their parenting skills and relationships with their children, was one of hope, joy, and sadness. We got to know parents who made lasting progress, and we lost parents to relapse, incarceration, and overdose. It was a constant reminder that what happens in court is a small part of a much larger system of services, supports, and agencies that have a more direct role in individuals' lives, while highlighting the role the court can play in bringing everyone together to work towards improving our communities. After my appointment as a superior judge, I began to hear cases primarily in the Windham Civil Division, while offering support for the Windham Family Division, and on a very limited basis, the Windham Criminal Division. Most of my week was spent on evictions, collections, small claims, anti-stalking orders, and garden variety civil litigation, with the occasional appeal from probate court. The remainder was spent in relief from abuse hearings and contested divorce and custody hearings. These were two completely new worlds to me. And over the course of my 18 months sitting in Windham County, I went from last thinking about the rules of civil procedure as I studied for the bar exam, to a sufficient basic knowledge in the relevant law and procedure from which to address the disputes that came before me. This process was not painless. I made mistakes, and many of my decisions were significantly delayed. But I continued to learn and became more comfortable with the decisions I had to make. During this time, I was fortunate to have the support of dedicated and experienced staff and my fellow judges who were always willing to offer guidance, insight, and a helpful sounding board. In September, I began sitting in the Bennington County Family Division, hearing divorce and custody proceedings, as well as abuse and neglect, truancy, delinquency, and youthful offender matters. I've enjoyed continuing to hear divorce and custody actions and returning to juvenile proceedings, an area that I feel both comfortable in and passionate about. Despite the challenges, the stress, and the workload, which are all formidable, I love my job. I am immensely grateful that I can bring what I learned as a public defender to my work on the bench. It is fundamental to our society that we treat individuals fairly and equitably, uphold the rule of law, and ensure that all who come before the court are given the opportunity to be heard without bias. I take great care to run a courtroom that is welcoming to all litigants, where the rules are the same for all sides, where people are treated with respect and kindness, and expectations are clear. I am not always successful, but my hope is that anyone who comes before me, either seeking resolution to a dispute or to be held accountable for their actions, understands why they're there, what they must do, and the basis for any decision or order they receive. Even if they disagree with the decision, my goal is that they will be able to accept the decision as fairly made. I believe that we all, before our day begins, in between hearings, and as we end our day, consider how to best approach whatever difficult situations we will face that day, and review what went well, what could have gone better, and look for answers that we didn't have or different tactics that we could have employed. Every judge I know wants to do their best. It was deeply moving to see that despite my inexperience, most of the attorneys and staff who provided feedback believe that I should be retained. I was also glad to see that my efforts to approach each case without bias towards any side, with the appropriate attitude, with the proper preparation and background knowledge, are recognized by many. I was also not at all surprised to see that many attorneys and staff believe that I have not issued decisions in a timely fashion and need to make significant changes in this area. I agree with them. While I made progress in developing my knowledge and skills, I continue to struggle to issue decisions and orders even within 90 days. I was aware that I needed to do better. Delays in decisions can cause harm to litigants who face uncertainty while they wait and can add to existing conflict, lead to additional litigation, and impact their faith in the court system. In the winter of 2025, I started to focus on addressing the backlog of decisions I had amassed. In March, I began to work directly with Judge Zone on an ongoing basis, developing a work plan, accepting some appreciated relief from retired judges, and reporting regularly on my progress with issuing decisions. I identified that I would benefit from ongoing check-ins with a more experienced judge, and I began meeting weekly with Judge Tomasi, which I continued until this fall. The support I received from Judge Zone and my colleagues was fundamental in the progress that I made. Also, in June, I was diagnosed with attention deficit disorder, which I have been addressing with medication, therapy, and work on my own to learn and practice new skills and habits. This has transformed my professional and personal life. My ability to maintain focus, to avoid distraction, and to complete everything from routine tasks to lengthy decisions has dramatically improved, and I can see the change in my output. In late March, I began tracking all of the decisions I had under advisement. At that time, I had 51 decisions that had been under advisement for more than 30 days, and 23 of them had been under advisement for more than 90 days. This is not acceptable. By the end of December, I had 20 decisions that had been under advisement for 30 days, 10 of which were past 90 days. By the end of January, I had no decisions past 90 days and only 10 over 30 days. I now have 6 decisions that have been under advisement for more than 30 days and none that are at or past 90 days. This shortened list is a function of both finishing up older decisions and completing newer decisions before they reach 30 days. I have also stayed on top of the more routine motions and stipulations that come in on a daily basis and continue to be prepared for my hearings. Some of this improvement is simply a result of time and experience. Writing my 10th divorce decision was much easier than writing the first or even the 5th. I have become more comfortable with the weighty decisions we are tasked with and more confident in my judgment and reasoning. EDD treatment has also made a significant difference. With increased focus, I am simply able to work faster than I could before. My ongoing work with Judge Tomasi has made me more comfortable with reaching out to others when I feel stuck, even with something minor. With increased knowledge and experience, I also am more comfortable with issuing decisions from the bench and take fewer decisions under advisement. I keep close track of my work responsibilities, devote time daily to writing decisions while using checklists to stay on top of my other tasks. I have learned that even 20 minutes between hearings is enough time to make some progress on a pending decision. And finally, I've worked with my family to redistribute household and parenting responsibilities so that I can better prioritize my work. Without their support, including their willingness to move across the state with me, I wouldn't have made it this far. I believe that all of these changes mean that I will be able to sustain the progress I have made and issue decisions in a reasonable timeframe on an ongoing basis while continuing to grow in this role. I look forward to continued work with Judge Zone and my colleagues as I strive for continued improvement. I hope that I will have the opportunity to do so. Thank you.
Thank you. So I will start the questions off and then we'll circle around the table. So you mentioned a few different, I guess, methods or factors that you've kind of gotten your hands around, I guess, to really address the issue of timeliness, which was, as you saw, brought up a number of times, a concerning number of times, I think, in the reviews. So I'm wondering if I heard you say just now things like time, the gift of time, learning on the job, increased confidence, certainly treatment for ADD, and kind of generally becoming more comfortable asking for help. Those are some things I heard you identify just now as ways that you're addressing the challenges that you faced in the beginning. So I wonder if you can tell us even a little bit more about what you've done to address these big concerns, and what other factors you might have identified that contributed to the delays, to the issues with timeliness, and how you're addressing those factors. So I don't mean to ask you to repeat yourself, but because it was such a feature of the materials that we have available to us, it seems a really important thing to expand on if you're able.
Sure. Well, something actually that I neglected to mention is another strategy that I have used is very consciously using the law clerk as a support, which I did not do very much in my first 18 months. Having someone available to me to research and do some writing to help me learn about legal questions that come up in a case was something that was not a support I'd ever had before, and did not understand how to make good use of. And so when I moved to, I would say that last spring, I started more intentionally giving work to the law clerk that I had at the time. And then in moving to Bennington, I went in with a goal for myself that I would develop a working relationship with the law clerk from day one and make sure that I always had something for them to work on. I think I was resistant to giving someone else work that I felt I could do myself. And I realized I had to get over that. And so I don't worry about whether it's something that's worthy for the law clerk. I just say, here is something I need looked into. I give it to them. And when that comes back, I give them something else. And that's been very helpful and saved time. I think that making more time in my workday outside of work hours, outside of court hours, particularly, most days in juvenile court, I'm on the bench from 8:30 to almost 4:30 with things to do in between. And so I very consciously leave early for work so that I can get work done before the day starts. And I have a certain amount of work that I expect myself to finish that day, and I don't leave until it's done. And I also look at decisions that I have under advisement, and I look at the windows of time in my week and figure out what I'm going to work on then, and have an idea of how many decisions do I want to get done during the week and during the weekend, so that I can keep things from getting past 30 days, and also continue to deal with the things that are still over 30 days. I also have found that the faster I work on the decision, the easier it is to write, because while I take very extensive notes, things are still fresher in my mind and they're easier to address.
My one quick follow-up is, especially because you're mentioning, it sounds like you might be working 7 days a week. And so I just want to ask about sustainability for you and, yeah.
So, well, I do work on the weekend, which is something that I think unofficially most judges I know do. I do find that I do better if I give myself one day off. And so unless there's something that really has to be done, and fortunately, I have, I think, gotten past that point. I do try not to work on Saturdays.
Thank you. Senator Hardy, you want to get us, continue on?
Sure. I have a couple questions. Hi, thank you for joining us. I mean, I share the concerns that were expressed pretty clearly in the responses that we got about the timeliness of your work. It does sound like you've made a lot of progress, and I think that's great. I wonder why it took you so long to seek help. You had been a judge for over a year, it sounds like, before you started working with, before you reached out to Judge Zone and then got connected with Judge Tomasi. Were there any sort of warning signs that to you to before that? Why did it take you over a year to ask for assistance and guidance?
Well, I think in the beginning, I expected it to be difficult. And I unfortunately was commuting to Newfane from South Burlington. And so on days when I had court, I was spending 5 hours driving. And so at that time, I attributed a lot of my challenges to the commute and my level of exhaustion from the commute and just simply not having enough hours in the day. And so I pretty quickly identified that commuting from South Burlington was not sustainable and that we needed to make a plan to move. And we did, and moved as quickly as we could. And I just really tried to stay above water during that time. And I thought that once we moved and I wasn't dealing with the commute, that I would be able, putting in the time to catch up. And what I found after the move was that it was easier. And by that point, I had a better understanding of the law that I was working with. And so I was able to make a lot of progress. But I also found that I just couldn't, there was a level of progress that I couldn't get past.
Mhm.
And I really struggled to understand why. I questioned whether I was up for the job. I wasn't sure that I could keep up with the work. And it was a very distressing time. I was not happy with the delays. I felt that I had never been so bad at any job in my life. And I didn't want to be that bad. I wanted to do good work and get decisions out. And I really couldn't understand why, when I was working at that time as many hours as I possibly could, I just couldn't catch up. And it's not as though I wasn't reaching out for help at that time. I was in somewhat of a unique position in Newfane because I was the only judge in that courthouse. So I didn't have a lot of interactions with other judges day to day. But I did start occasionally intentionally working out of the Brattleboro courthouse when I could, and consulting with Judge Mann and Judge Treadwell, who were really helpful and who I got to know. And but it was really that winter where I really wasn't sure what to do.
Mhm.
And so when I began communicating with Judge Zone and put together a work plan, I hoped that it would work.
Mhm.
And it really wasn't until I, at someone else's suggestion, actually, looked into an assessment for attention deficit disorder. Because while I have, now that I look back, struggled with things like time management and general executive function skills, you know, since at least second grade, it had never occurred to me that there was a reason for that other than, you know, I just was disorganized. And I don't think without that diagnosis and the treatment that I would have been able to catch up.
Do you, I mean, it sounds like you were assigned a court where you were the only judge, so you had no judicial colleagues in the building with you. You were assigned a court that was a really long drive for you. And you were assigned a docket that was not your area of expertise to start with. I mean, did you know that that was what the assignment was gonna be when you applied for the job? Or was that what you were assigned? I don't actually know how it works. Were you assigned that after you were sworn in and that was that?
So I knew that I had been appointed to a particular geographic area of the state that includes Orange, Windsor, and Windham County. And it was my hope that I would be assigned, at least initially, in Orange or Windsor County, so that that would give my family and I time to look at making a major move. But after I was appointed, I don't remember exactly when we learned our assignments, but I was assigned to that position because that's where the judge who had retired and whose position had opened up, that's where I went, because that's where they had a need for me.
But now you're in Bennington?
Now I'm in Bennington, yes.
Okay, so you might come up to Washington or Chittenden again, even though you've moved to the southern part of the state?
So when we are assigned out of our geographic area, it's only by agreement. So I was asked if I would be willing to go to Bennington for this assignment. And I accepted it first because I was happy to be assigned in juvenile court. And honestly have a break from civil court. And I also knew that the driving time between Windsor County and where I live and Bennington County where I live is the same. So it's just a little less than an hour, which is not that bad.
Okay. I have another question, but I'll reserve it till the end and see if somebody else asks it since I went first. So, thank you.
You represent Emily.
I don't have a question, thank you.
Evening, Your Honor.
Evening.
So we've been going through the reviews, the comments primarily, and a lot of the staff acknowledged that you were new, that you were good to work with, that some of them found that you were inefficient with your time. You've pretty much acknowledged that. And the one that really stuck with me was the attorneys. A number of them said exactly the same thing, that, so you went out, you sought help, you were diagnosed and you got help. And how many cases between that time and right now, can you tell me how many you think you've had?
How many decisions I've issued?
Yes.
Well, I can say certainly all of the, 53 that were on, or 51 that were on the original list, and then, throughout June, July, August, September, October, November, I would say, probably at least 4 or 5 contested hearings a month, like lengthy ones, along with shorter decisions that come in. So My best guess would be, hold on. Math is not my strength.
Mine either.
I don't know, at least 50, at least another 50, but maybe more,
Yeah.
probably more.
So the attorneys that commented, were over the period of your, your first term as judge. Did that,
Yes, the feedback is all from attorneys in Wyndham County, not from attorneys in Bennington County. And what I will say, a really unfortunate consequence of having a backlog when you are feeling pressure to rightfully to finish up the oldest decisions means that all of the newer things wait until the oldest decisions are done. So that means that while I was still working on overdue decisions over the summer and the fall, other things were waiting until I finished those up. And it's only in the past month or so that I have felt that I could devote time to, now, there were cases where there were, emergent situations where I had to, issue a decision within a couple of days or a week. But decisions that were not that kind of emergency, most of those would sit for at least 30 days or 60 days. And it's only now that I feel like I am consistently addressing things before they even get to 30 days. And I hope with continued progress. I remember one attorney commented that they got very frustrated in the domestic docket, because they were used to judges issuing temporary orders, at least by the next week. And that's my goal as well. That's what I should be doing. And now I feel that I'm in a position to do that.
so you honestly believe that you're better able to focus and to manage your time. You've really been working on that, and that's a good thing. So thank you very much.
I do honestly believe that. And I think that the progress I've made in finishing up cases while continuing to issue decisions on an ongoing basis shows that.
Good, thank you.
Thank you. Thank you for being here. Yeah, this is hard because there is definitely some conflicting assessments of your work and the timeliness, et cetera. A lot of it is around, the slow processing of the work, but there are some really nice things as well. I was very impressed with her kind and thoughtful work on our case. She's impeccable judicial temperament and one of the smartest judges I've appeared before. Her orders are fair and follow the law. So from where I'm sitting, this is just hard because of these conflicting, criticisms and praise at the same time. So I guess I'm wondering, you're probably under a lot of stress, I would imagine, and I'm sure it's hard to read the critiques. And just to sort of piggyback on what Senator Williams said, is this something that you are really feeling like? Is this something you love and you want to continue with and you want to continue to work on and work with? And I guess I didn't hear that from your opening statement, like the love, the joy, because we do hear that sometimes when we listen to judges give their opening statements, how much they love the work. And I'm just wondering if you could comment on that at all.
I think that the first several months of my term, I don't think I did love it. I think I was very stressed and really struggling and really questioning what I had taken on. And I will say, however, that I did get to a point where I am happy to get up every day and go to work and see what comes before me. I really enjoy working directly with litigants to try and understand what is it that they want. in a small claims case, in a custody case, what are they hoping to get from the court? And to work with the other party to understand, well, what is it that they want? And then, they put so much trust in the system to hear them out and give them a fair decision that's going to last and is going to work for them. And I certainly made many decisions that made one side unhappy, but I try, particularly when it's an issue of custody, parent-child contact, or in the juvenile division when it's a question of actions that parents need to engage in, parent-child contact, to really understand where people are coming from and give them something that they can understand and that they can work with in their life when they go out of the courtroom. And I find that incredibly meaningful and rewarding. And, there are days when, like this morning, someone swears at you and hangs up. But that's not every hearing. And even then, I hope that that person is going to read the written order and reflect and understand why it is I couldn't do what they wanted me to do, and understand the next step that they need to take so that they can get what they want. I mean, really, my whole career has been just trying to help people be treated fairly and make it through their lives. And I still get to do that, just in a very different way. And so it is hard, but I do really find meaning and enjoyment of it. And it is better now that I am under less stress.
So I can only imagine the drive here was tough, was difficult because you, I think, based on the survey results, knew what we were going to be talking about for the most part tonight. And I don't mean to keep bringing it up. Nonetheless, over half or just about half of the attorneys focused on the timeliness of cases being resolved, and 2/3 of the staff had the same concern about the speed at which things were happening. Nonetheless, you have freely admitted that you knew or now know that you have a problem or there's an issue with the timeliness. You've made tremendous progress, it would seem, and indicated you feel like you've turned a corner in some respects. I'm wondering if there's someone, you mentioned Judge Tomasi and Judge Zone, sort of who's able to give you a progress report as well. Self-reflection is a wonderful thing, but until you can bounce that off someone else that has a little bit more objectivity, it may be not enough. So is there someone that regularly says, you're doing a great job, here's some suggestions, or is just this sort of self-reflection?
So unfortunately, we don't get a lot of opportunities for that kind of feedback. No one, or very infrequently does someone come and sit and watch my hearings and tell me how I'm doing. I did have that opportunity when a retired judge, I think, went around and watched all of the recently appointed judges' hearings, maybe I feel like it was in the spring, and gave us feedback, and that was really tremendously helpful. But I think the feedback that I get about my progress comes to me in two ways. All judges use a system called Enterprise. I think that's what it's called now. And a task queue, and in your queue are all of the things that have been sent to you to do in different dockets. And every day I can see how many things are in my queue. And there was a time several months ago when those queues were regularly between 50 and 100, and I was just constantly battling them down. Now my queues don't get above 15, and most days I empty them out completely. I also keep track of, have I issued all of my entry orders from today? All of the forms that go along with it, am I on top of that? Or have I gotten behind? And so when I say that I have checklists for things that I see as daily obligations and weekly obligations, and I track that. And as for decisions, every month, the COM for each court collects a list of every decision that is over 30 days and sends that up to the court administrator's office and the Supreme Court. And so looking at those lists, I can see how many things do I have on that list. And so right now, I know that I have 6 things that are over 30 days. And by the end of the month, at the rate I'm going, I should have nothing over 30 days. And that's where I want to stay.
Okay, thank you.
Thank you for being here. We've covered a lot of territory already, I guess, regarding what's going on in the past, and I'm interested more in the future. I've heard you say a lot of things are going better and you like how that is, but I mean, is this something that you want
Yes.
and why?
If I didn't want it, I wouldn't have gone through this process of retention. I knew what criticisms there would be, what feedback there would be, and I knew that certainly everything to do with my timeliness and inexperience was correct. And I knew that I would have to face that. But continuing to work in, and I don't want to say just the juvenile division, because you don't get to always be in the same court. And really, by the end of my 18 months, even the civil division started to make sense to me. And I came and helping things move forward. And I love doing that, and I want to continue doing that.
Glad to hear.
Thanks very much, Judge. I think it's really commendable when, people ask for help, and you mentioned you really benefited from your time with Judge Tomasi there. But I'm wondering specifically, how did you benefit from that time? Maybe one big takeaway that you incorporate in your job right now? Maybe
Yes.
that experience?
So, one thing I realized when I was trying to make progress back in the winter and the spring was that I was really struggling with what should have been really easy decisions. Things like disputes over discovery. And it was, I felt, because while I could look at the statutes and I could look at the case law, I didn't understand the culture of civil litigation. The way that civil litigation, the way that discovery done is very unfamiliar to me. Having experience in criminal and juvenile court, where it's just very different. And so it was hard for me to say, well, this is outside of this is an unacceptable delay. I will give you attorney's fees for your motions. Or this is unacceptable delay to the point where I am going to impose sanctions. And so having someone who, and I took those decisions very seriously, and I did not want to get them wrong. But I also realized you can't just sit on the decision forever. People need to get their discovery sorted out so that they can move forward with their litigation. And so I approached Judge Zone and other judges and asked for suggestions as to who had a lot of experience in civil practice and litigation, that they would be a good sounding board. And so Judge Tomasi's name came up. And so I approached him, and I think maybe Judge Zone also approached him to see if he was willing to make the time commitment to meet with me for like an hour or two every week, which is a big ask. And I very much appreciate that he was willing to do it. And so I could just go over with him every week the things that I was stuck on, and where I could say, this is how I'm looking at this, and this is why, but is this way out of line? And a lot of times the answer was no, you are looking at this the right way. But sometimes the answer was, well, have you considered this? Or have you looked at this? And that really helped me both move forward faster on things, but also develop confidence in my judgment in that area, where I felt like I didn't have that depth in personal experience in that kind of litigation.
Thanks very much.
And so in the future, I think I would seek out that kind of help again if I needed it, rather than just sitting there going in circles.
Yeah, following John.
Yeah.
Thank you.
Go ahead.
Okay, nobody asked my questions, so I'm gonna ask them. This is my 8th year serving on the Judicial Retention Committee, so I've seen a lot of judges. I think I've seen almost every judge. And one of the things that two of the markers of what I look at when I'm evaluating judges are, one, their decisions and how well they're written. And then 2, how they reflect the judiciary. I think it's really important that we have a judiciary that is respected by Vermonters. And I've said this just a week ago on the Senate floor. And I am really concerned with the numbers that Senator Collmore, laid out about the number of attorneys, number of staff that are concerned with your performance and your timeliness. And the people who didn't get to fill out the surveys were all the people who had cases before you and had to wait months and months before a decision was made about things that were really important in their life. And then in reading your decisions, I found them kind of confusing. And I'm not aware, but I've read a lot of these decisions by now, and I make the laws that you interpret. So I'm concerned about how your performance is reflecting on the judiciary to Vermonters who have to interface with the court. And so I'm wondering, first of all, in all this, the work that you have done to improve, have you gotten any kind of feedback on your writing and how you're presenting evidence in your findings and then your decisions based on those findings? And then second, how do you respond to the sort of trust issue that I'm bringing up and how people see the judiciary and trust in the judiciary?
So the feedback that I get on my findings generally is just limited to when I have assistant judges sitting on a case. They review those decisions before they go out and give me whatever feedback they have. But unless someone files a motion to reconsider or a motion to correct an error, I don't hear directly from litigants or attorneys about my decisions.
No, I mean, when you were working with Judge Zone or Judge Tomasi, did you get any assistance in your writing of your decisions or pointers?
No, I don't know that they would have ever read my decisions. I think the only time Judge Zone would read a decision is when there's a motion to recuse, and then he would review all of the cases. But that wasn't the kind of assistance that I was getting.
Okay.
But I'm certainly open to any support in that area.
Because I've heard other judges say, and I agree completely, that when a case is done and the opposing sides read it, even if they don't, it's not ruled in their favor, they should be able to understand why you came to the decision you came to and respect the decision that you came to, even if they don't like it. And so I think it's really important to be able to write a good decision and clearly make your arguments for how you decided what you did based on the evidence that was before you. And that was hard for me to follow in your decision. So I definitely think you should also seek some feedback on that to make sure that the average person who might be reading them understands why you decided what you decided. The one that was particularly you cut off the names of the cases, so it was the one about the fire.
Oh, the Daubert motion?
Yeah.
Mhm.
So, and then what about the sort of trust in the court issue and how do you? I mean, you've made a lot of improvements, but if you continue on as a judge, I want people to be able to walk into your courtroom and believe that they're going to get the best justice they can in Vermont, and that they're going to get it in a timely fashion, and they're going to understand it. And I'm not sure that's happening right now. And so how, moving forward, do you intend to make that happen?
Well, I think that in Bennington County, I've had the opportunity to work in an area where I was more comfortable, and with attorneys and litigants who were seeing me completely new to the job. And so I hope that their experience has been different, but I acknowledge that maybe it hasn't. But I take all of these concerns that were raised very seriously. And they were things that I was have been trying to address and addressing over the past several months. And I will, I understand what this job requires of a person. And I am committed to bringing that every day. That's the only option. And so all of the ways in which I hold myself accountable, I will continue to do. And I would welcome the opportunity to work with anyone who would continue guidance in ways that I can improve, and any recommendations. I will say, when it comes to writing decisions, I know that the National Judicial College offers a writing course for judges, which is something I'm interested in, because I do want to write decisions that are that people can understand and have reasoning that makes sense. And that is something I have been thinking about and would consider doing.
Right, all set?
Yeah.
Well, thank you very much, Judge Malone.
Good.
All right, going back to our Honorable Benjamin Battles. Thank you for being here. Floor is yours.
All right, thank you. And thank you, Chair Arsenault, Vice Chair Elmore, members of the committee. I'm grateful for the opportunity to appear today and support my request to be retained for a full 6-year term as a Superior Court judge. I was appointed to the Superior Court in December 2023. After completing my orientation, I was assigned to the Caledonia and Essex units to cover the family division, covering domestic cases, juvenile cases, and RFA and stalking cases in those two counties. In September of 2024, I rotated to what we call the Northeast Civil Float position, covering the civil divisions in Caledonia, Essex, Lamoille, and Orleans. I live in Waterbury, so I'm also on the road quite a bit, ranging, Hyde Park for Lamoille is my closest commute, and then occasionally out in Guildhall, which is about a 2-hour drive from where I live. In addition to my assigned rotations, I've also regularly covered for other judges when they have personal or scheduling conflicts, I think as all of my colleagues do from time to time. As a result, I have sat in the criminal divisions in Caledonia, Essex, Lamoille, and Orleans, as well as the Lamoille Family Division, and covered a couple cases in the Washington Civil Division as well. So the past 2 years have been an incredible learning experience. I don't know if anyone walks into this job without a big learning curve. Maybe there are some of my colleagues who were born for the role, but that was certainly not my experience. I have had to learn constantly, and I continue to do so every day. We all come to these jobs with our own experiences as lawyers and in life, and so I had a different experience than Judge Malone, and my practice experience, both in state government and in private practice, was focused on appellate litigation and complex civil litigation. I spent a lot of time in the federal courts. I spent a lot of time at the Vermont Supreme Court. I worked on a wide range of cases in different jurisdictions, both within and outside Vermont. But I did not have the daily experience of practicing in the Superior Court the way that a public defender or deputy state's attorney might have. I typically worked on, more complex civil cases with lawyers on both sides. I spent a lot of time writing briefs about constitutional law. And when I went to court, it was usually to argue a motion or argue an appeal. I had time to prepare, and I usually would wait, weeks or months after that argument to get a written decision from the court. Then I became a trial judge. On my first day on the bench, I remember being in St. Johnsbury at 8:30 in the morning with a room full of self-represented litigants for the weekly relief from abuse. I had to roll from the bench after each 15-minute hearing and make decisions that had huge consequences for the people involved. Will they be safe? Can they go home? What's their kids? So I had to learn very quickly and I had to adjust. I got through that first day and then the next day and eventually the next 2 years. As I've begun to grow into the job, I've tried to follow a few basic rules that I apply to each case, regardless of my familiarity with the docket or the subject matter. Treat everyone with respect, be prepared, ensure procedural fairness, be humble, and be decisive. So just going through those, treat everyone with respect, and that includes the parties, the lawyers, the witnesses, the security personnel, the assistant judges, and the staff in the courthouses. Be prepared. The level of preparation needed on any given day depends obviously on what's going on in the case. What are we doing? Is this a status conference? Is this an evidentiary hearing? Is it a trial? But at minimum, I want to know who the parties are, what the dispute is about, what the relevant legal framework is, particularly in the civil division. The civil is kind of the everything else division. The other courts have limited jurisdiction governed by a set of statutes. Civil is that you can't go in criminal court, you can't go in family court, you go to civil court, essentially. And then at every hearing, I try to think about what are we doing? What are we trying to accomplish today? What am I going to come out of here doing? I'm going to have an order that's going to guide the case going forward and move the case toward resolution. When I was sitting in the family division, especially in the juvenile cases, it was also, I think, critical to know about the kids that are involved in the case, what their names are, what their ages are, what their concerns are, the reasons that they're involved in the court system. Ensure procedural fairness. So that means, at minimum, ensuring due process. That's a constitutional requirement under both the state and federal constitutions. And at minimum, it means that the parties have notice and an opportunity to be heard. So they need to know what's going on and they need an opportunity to present their position on this. Ensuring procedural fairness can sometimes rub against efficient case management. We all want to move our dockets, we want to get cases resolved, we want to keep things moving, but sometimes you have to reschedule things, you have to continue the hearing. And so that's, I think, part of the art of being a judge is reconciling those competing concerns. I think it's very important to stay humble. Sadly, I did not get any smarter when I became a judge. I recognize that I don't know everything. There's often a lot going on behind the scenes of the case that I don't know about, and I will never know about. I try to approach each case with humility and an open mind to try to figure out what is going on, what the facts are, you know, what the relevant laws and rules that need to be applied to the case. Nonetheless, I have to be decisive. I have a job to do, and I'm responsible for managing my docket and deciding the matters presented to me. Used to teach a case on a seminar in Vermont constitutional law under the state constitution, and you know, there's a provision in the state constitution. Every person within the state has recourse to the laws to obtain right and justice promptly and without delay. So I strive to efficiently manage my docket, to rule from the bench when I can, and to issue written decisions promptly. It can be really challenging, as you've heard. You know, we work in the enterprise, you know, our case management system, you know, we have a queue of things that come in all day long. You know, I'm in 4 different counties, so Caledonia and Essex are essentially one unit. But so I have the civil and small claims dockets in each of those counties. So I have 6 judicial assistants in those counties who are sending me things as they come in all day long. And so you can just sit there and look and watch like this as your list of things to do comes in throughout the course of the day. And, you know, I think one of the things that I tried to get better at is you have those things on that list. You have things you have to write following a hearing. You have a bench trial. You need to write up a decision. And figuring out what can be done, what needs to sit in the queue, and you just need to trudge through it and get, you know, write this decision, write the next decision, write one after that. But then you have to kind of jump around and be like, okay, I can do this in 10 minutes. I can do this in an hour. This is going to take me a whole day, so I'm going to save that one for. So that's been something that I'm continually trying to get better at, is figuring out how to triage or prioritize or whatever word is most appropriate to figure out how to get things out quickly that can be gotten out quickly and save the more complicated stuff for when I have a day, a findings day, as we call them, built into the schedule. Or if I have a trial settle or something like that, where I find myself some time and actually can take a whole day and write a decision and not leave the thing that's going to take 25 minutes to write until I get that whole day. So that is something I'm continually trying to work on. I have leaned heavily on my colleagues over the past 2 years. To a person, they have been incredibly generous with their time. The code of judicial ethics that we're bound by limits who we can talk to about the difficult issues that come up in our work, but we thankfully can talk to each other. You know, we have some of the newer judges, you know, we have a chat in teams that we talk to about things that we maybe don't want to raise with a larger group, and we lean on each other and ask for quick advice. I have certainly called you know, many other judges who I know are experienced in a particular area. If I'm having to cover some criminal work, I have, you know, judges who I know have a lot more experience in that area than I do, who I can give a call. I was assigned as a mentor when I started, Judge Mary Morrissey, and she's been incredibly helpful as I got up to speed. Judge Jonay has been an incredible resource. So I'm really grateful for my new colleagues and their help. I'm also grateful for the support and counsel of the staff in the clerk's offices that I work with and the assistant judges in the counties where I work. They really help provide the local and logistical knowledge that I often lacked as a new judge coming in from out of town. I've also enjoyed the other non-courtroom parts of the job that go along with it. I've served on 2 different committees right now. Public Access to Court Records Committee, as well as the newly created Delivery of Legal Services Commission. Really excited about the work we're doing there. It's very obvious to me working up in the kingdom that there's a real access to justice issue. Many of the litigants in my courtroom are self-represented and have a lot of difficulty navigating the system. So I'm hopeful that we can take some concrete steps on that commission to just improve access to justice in the state. And mention, you know, it's had opportunities to get together with other judges too at the trainings that the judiciary offices offers several times a year. We do a Vermont Judicial College in the summer, and I recently in the fall spent time at the National Judicial College in Reno for their orientation program, and that was really helpful. As I said at the beginning of my remarks, the past 2 years have been an incredible learning experience. I view this retention process as part of that experience, and I'm grateful for the supportive comments as well as constructive feedback that I have received in the survey responses. I welcome any questions that the committee may have.
Great, thank you so much. We'll start with Representative Casey.
Great, thanks very much, Judge. It's, reading the comments, it sounds like you've really taken to it as a new judge, but both yourself, Judge Malone, have talked about the challenges of just jumping into this. And, I've always been curious, like the Vermont bar is so small and interconnected, right? And all of a sudden you find yourself on the bench, appearing in front of colleagues that you've probably worked with over the years. Could you talk about how you maintain professionalism and you stay away from favoritism when it's that small community and you're in that role for the first time?
Certainly, that's a good question, and it certainly comes up. And I worked for most of the 10 years prior to my appointment at the Attorney General's office, which is the largest law firm in the state. And I see those folks. I see other folks that I may have worked with or against, and so it's not uncommon to know the attorneys in the courtroom. So I think, I try to, if I had a relationship with someone that was more than just a casual sort of working relationship, I will make a disclosure. If it's something, and my test is kind of, one is that something that I feel would affect, and then that would be a recusal situation if I felt like it would actually impact my decision making. If it's something where I could imagine the other side wanting to know, I will put that on record. I have a little language that I use if I make a disclosure that cites the rule, and then they can make the motion to recuse if they are concerned about it, and then that will go to Judge zoning for resolution. And then, so that's on the more formal side. And, outside of the courtroom, I just try to conduct myself professionally and certainly don't talk about my cases with friends and acquaintances outside the courtroom, and just try to remember that while I might not be feeling like a judge when I'm off the bench, I still am.
Thanks a million.
Thank you for being there. I have no questions. I will pass the torch to Representative Arsenal.
All right, thank you. I have a couple of questions. I was really, just want to start with, I was intrigued by all of the decisions you chose to share, but one of the cases in particular involving was the parental rights and responsibility and PCC case. And it made me think a lot about Vermonters who appear before the court who have various disabilities. And I wondered if our systems are largely built from an ableist point of view. Expectations are set with, certain through an ableist lens. And so I'm wondering if you modify your thought processes or logistics or anything when you are working with folks who have disabilities, and if so, how, and if not, why?
So yes, we do, and that case was an example, and that I shared that. I hesitated before I shared that one because I feel like it's something that people could go different ways on, but I felt like it reflected me honestly grappling with what was going on in the case. But in that situation, one of the parties initially did not have any counsel, and we had a number of hearings. There were some hearings about whether the case was going to go to California or not here, and then I informed that party. We had hearings, and it was clear that the party would really benefit from having an attorney, and we continued it a couple times, shared resources about, places to call, the Bar Association's referral line called legal aid and, ultimately she, an attorney did come into the case, which I was very grateful for. If my memory serves, I believe she also had a communication support specialist who was present, and that's something, if a need is identified or if it's requested, it'll to the judge to sign off on, and that's not uncommon. And then we also had interpreters in that case for the witnesses. There was several witnesses who were Spanish speakers, so we had interpreters translate that. And it can be logistically challenging, but I think it's critical. It goes back to that procedural fairness of having notice and an opportunity to be heard, and both of those things. And you need to understand what's going on and be able to communicate. Recently had an eviction case in Caledonia where the tenant was deaf, and so we had an ASL interpreter, and we initially had it set for a bench trial with the interpreter on WebEx, and the tenant was in the courtroom, and it was not working, and so we had to continue and reset it, and directed that the ASL interpreter be present in the courtroom, which was a significant expense because I forget where they were coming from, but it involved like 4-hour drives that they charged for, but that was something that the court system paid for, and we needed.
Thank you for that. And this one, I invite you to sort of use your imagination and don't consider money in answering this question. Because I am really curious about this. The issue of work-life balance comes up very frequently in these proceedings. And it sounds like, by all accounts, it's a bit elusive in this role. And so you mentioned in your letter of intent that trying to find a healthy balance remains an ongoing struggle. And you talked about the ability, like adequate sleep and being fully engaged with your life off the bench. These are both really important, both, just to you as a person and to your ability to do your job. So I'd love if you can spend a minute or two just sharing what's the ideal scenario? Is it like 15 more judges? Is it, and on the corresponding court staff, like what would help? Because it just seems like a real intractable issue, but it also seems like a really important one.
In a perfect world, I think it would be more of all the things. So I think more, I think what, and we get better at managing it and balancing it, right, as judges get more experience, but the caseload, the docket and caseload pressures, the combination of the amount of things you have to write, the amount of times you have to be in court, and the fact that most of us are commuting quite a bit. So it is difficult to balance. And I find it, it's hard to find the time to write the stuff you need to write when you're on, if I'm waking up at 6, I'm out of the house at 7 to start court at 8:30, till 4:30 or 5, then getting home at 6 or 7, I have a kid, I have family, and, if I'm gonna write, it's happening from like 9 to 12, so it's a struggle. And I think part of it comes with efficiency. I mean, I do think it would, the nature of the geography of our state is difficult, right? If everyone had a 15-minute commute, that would give some time back for sure, but that's, I don't think, realistic. The majority of the, attorneys in the state are, probably in Washington and Chittenden counties. And so, those are the people who end up becoming judges, not exclusively, but many of them, myself included. So, I think more judges, more staff would help. I know that a lot have been appointed recently, and I think it has helped. I do think I'm getting better at the balance than I was when I started. But it's still a struggle, and particularly if you have things going on in your life outside of work that demand attention.
Maybe we should think about prevention, community building, things that keep people out of the courts, but just a thought.
Thank you, Madam Chair.
Thank you.
So you did very well in the survey. 96% of the attorneys recommend retention. Senator Hardy asked a question earlier, and I was struck by one of the comments, number 13 on page 18. Even when he, meaning you, has ruled against me, I have considered his opinions well-reasoned, even-handed, balanced, and appropriate. He is humble yet incredibly intelligent and considerate. I strongly recommend retaining Judge Battles. So I just wanted to mention that. You had 100% approval recommending retention among the staff. To me, they're equally important. And I know I've made a point before that in some ways it's harder to please all the attorneys because at some point, one of them isn't going to be happy with what you decide. And so that has a tendency to maybe flavor somebody's opinion. I want to thank the chair for a keen perception because I was headed in the same direction. So I've had the opportunity and the pleasure to know lawyers who then became judges. And I think 2 or 3 even became Supreme Court justices. And I want you to just very quickly talk about the challenge of it because it gets isolating at some point. You can't do the same things you did with your best buddies at one point in your life when you become a judge because it just doesn't work anymore. How difficult is that to sort of deal with that isolation?
So I feel it more in the workday than in my personal life. Most, for better or worse, a lot of my social circle is sort of parents of middle schoolers in Waterbury. So there's a lot of non-lawyers in that group. So I don't feel like I have to avoid a lot of social events because of that. But it is difficult during the day. I mean, as I mentioned, I worked at the Attorney General's office for a number of years and worked on some really stressful and difficult things while I was there. But it was very easy to walk down the hall and vent about what those no good judges were doing or or whatnot. But it's more difficult to do that. I mean, you can. I certainly talk and chit chat with the staff and the assistant judges, but it's a different dynamic because I can't really talk to them about what I'm struggling with as far as deciding the case is going. So it is difficult. I have, and it does vary by courthouse. I think as you heard from Judge Malone, some courts, you may be the only judge in the building. In St. Johnsbury, when I'm there's generally 2 other superior judges in the building, so I can. And particularly when I say my first rotation there in family court, I'll often come down and talk to, Mike Canton, the other judge in the building usually, and tell him about, what I was struggling with. And so those relationships have been really helpful, but it can be nice.
Thank you. Very good.
Thank you. Thanks for being here. This does not require an answer. It's maybe rhetorical, but if I could get an answer from some of the folks that assist us in this work, or maybe Terry, I'm just curious about what Angela, Representative Arsenault was talking about, which is the complexities of the work that you all are doing. And it's been interesting for me here with these new judges, because normally it's, we have more seasoned folks coming in. But I'm just writing down some of what I've heard tonight and what was written in your letter, which I really appreciated. But the commute, the lack of lawyers and folks self-representing, which takes extra time. We've heard that before. Technology, which hasn't really come up, but is often a stumbling block. The destabilization of COVID, and then just the complexities of modern society. I honestly can't imagine how you do it. So I appreciate you, both of you, but you being honest and open about the struggles. And it would be great to hear from folks who've worked in this area. Was this the same, 15 years ago? Was it like this 20 years ago? Because when we see the seasoned judges, it's just such a different experience. So anyway, I'll leave it at that, but thank you.
Evening, Your Honor. So I don't have any questions for you, just a couple comments. So you set very high standards for yourself. You got a high bar. And then when I read the reviews from your former peers and your your staff, see words like prepared, patient, integrity, fairness, humility. I really just want to let you know, I appreciate all you do, for us. I don't know if I could do what you do and be organized about it. And, they say when you've done a good job when you decide against somebody and they think you've done a good job. So, thank you.
Thank you.
I guess I don't have a question either, but a comment in a similar vein. I had written down that, someone had, in this, I didn't write it down verbatim, but, prompt, decisions, for most overall, most of your decisions, but in particular for the sensitive matters, like in the juvenile arena. So there's not always, but your priorities are right, so that when you are having, keeping that in mind, that, yeah, those are the ones that really do need to be decided promptly. That's great.
I feel like I should have a really good question. Kind of gotten it easy. So you were first assigned to the juvenile docket or the family docket?
So the family division for Caledonia and Essex, so it was the juvenile cases, the delinquency and change cases, the domestic document parentage and divorce, and then I was way they heavily meant to doing both the RA and stuff.
Okay. But prior to being a judge, most of your work was civil litigation, yeah.
That's right, although I did, in one of my jobs at the AG's office, I supervised all the appellate litigation, so I had a lot of experience with the chance docket. So I knew the substance of it.
Okay, because I almost feel like you guys should have switched dockets and maybe it would have been easier.
Yeah, I think
for both of
about
you.
that. Started.
Wait, and so, I mean, I see Judge Stoney is listening up there, so he'll know what my question is gonna be. So I don't have a hard question for you, but you mentioned in your list of things that judges need to be, which is decisive. And I'm wondering how you're decisive. How do you force yourself or make yourself or ease yourself into being decisive?
So one thing I've tried to do is increase the category of cases that I'm going to decide on from the bench and be more open to doing that, because sometimes it's very doable and it just takes a little bit of preparation, and something I've done, I do it almost all the time in small cases, for example, those cases. So I try to do a little research beforehand and be like, okay, these are the sort of legal ballpark that we're in.
Mhm.
I'm gonna be looking for, hear the evidence and then take notes and be like, okay, if it's A, B, and C, then it's this result. And so, so I'll try to do that. It does take a little bit of preparation and everything to familiarize yourself with the hearing. And sometimes you can do that in, other, landlord tenant disputes, or, I get a lot of personal cases, being in Orleans County, Caledonia County, and I tend, when those go to a hearing, I tend to write them up. But there are some cases where the facts are very clear and you know what the result's gonna be. So if I'm in that situation, I will take a minute, and then I can, they can just sit in if it's a furlough, case one way or the other, then they don't have to wait around and they can move on. But I think it takes a little bit of, yes, to directly answer your question, I think it takes preparation and some.
Yeah, you have to do your homework.
Yeah.
Basically, to come in knowing the facts of the case and then listen. So I can imagine the first couple times you roll from the bench, you're like, what if this is wrong? And then you're doing it and it's happening. So it must be nerve-wracking at least the first few times, and then you get used to it.
And I realized in the domestic docket, which was an area that I had no experience in before becoming a judge, that a lot of times they just make a decision.
Yeah.
You know, they cannot agree or abide by a decision of the court. And you're gonna say pickup's gonna be Wednesday at the police station.
Mhm.
And that's just ridiculous.
Yeah, people need that structure that you provide them with your decision. Yeah. I don't really have any other question, but thank you. It sounds like you're doing a good job. I appreciate it.
Thank you.
I think that's all for now. Thank you so much for being here.
Thank you very much.
Thank you.
Thank you.
Judge Harris,
Hello,
good
thank
evening.
you for having me. I'm trying to be cognizant of the time here, so.
You-
Thank you.
So I'm Judge Harris, and I thank you for the opportunity to discuss my request to be retained as a judge for a 6-year term. Vermonters find themselves in courtrooms in difficult times in their life, important decisions. We really want to be, we, the society, entrusts judges to make decisions. It's expected to be prompt without favor, applying the laws that the society has created. I'm fortunate to be so entrusted to do that. So from having found my life partner as a spouse, raising some children, I feel this is one of the most important things I've been able to do with my life. So I really value doing this. What I do is I try to approach this with a sense of humility and a desire to keep improving. This retention process is important. It's important for the judiciary, the society, important for the judges. We handle a high volume of cases. We have to act quickly and make important decisions. In that process, we get limited feedbacks. We get some decisions from the Vermont Supreme Court. If there's a deal, that's a limited context. This opportunity allows input. So I value the input. It's input to help me improve. What I'm going to do in my, particularly with time short, my submission statement, some of the questions of the retention question.
I don't want you to feel rushed. I don't want to interrupt, but please don't feel rushed.
All right, I'm trying not to.
Don't look at the clock.
Okay, well, give you considerable information about my background and some of it, and I won't repeat it all here. I think Senator Hardy was present my last retention
Yes.
6 years ago. The rest of you are not. But we're looking at the last 6 years. I mean, I've been fortunate to work in 5 counties now in the last 6 months. Over my next month, I'll have 10 years on the job, and I will have worked in 10 counties. But you may wonder part why that is. One thing, I moved a year into the assignment because I lived in Chittenden County, and then the governor. When I was appointed by the governor, I was asked to move out of the county because of the congestion of the judges in Chittenden County. We're seeing many judges out of Chittenden County taking the assignments, and they are moving to other areas of the state. There is concentration within Chittenden County. Part of the reason I'm in the various counties also is the way we do retention. There's a question about how does that happen? Judge zoning makes those assignments. It is like a 3-level chessboard. He's got areas of expertise, new judges, geographic dispersion, changing needs of the courts, different staffing levels. It's challenging. I submit I give my 3 choices, and I told Judge Zoning and Judge Grierson, but between them, if there's someplace better where you can use my talents, put me there. I'm flexible. I'll do what it takes to help fill in the balance, whatever it may be. My prior work was I had 29 years as a civil litigant, and actually in the last 6 years I haven't been assigned any civil work. There's reasons for that. With some of the floating judges, we've had to cover some of my assignments. So what I'll do is just briefly indicate, this period you're looking at and where I've been in the last 6 years, because what happened is before I came in retention on February 20th, I had started the year before in Windsor County, Judge Warren in the family division. Judge Warren was appointed. She got shifted to that, and I went to Caledonia and Essex. They are always doing criminal and family, the domestic side. We had another judge, it was Judge Griffin at the time, similar to what I think you just heard Judge Battles doing the juvenile, the RFA. So I was doing all the criminal and then family. So I came into retention about 2 months into that, and a month later, we had AO 47, the COVID hit, and we had the AO 47, we had the PG-13 was one of the other orders. We had the governor orders. It was a difficult time. And so that's what very quickly occurred. So in there, I mentioned in my materials I submitted, trying to work with the attorneys. And I had frequent bench barbs, and we talked about what was achievable, what was not. It got very complicated. In the criminal area where I was working, some of the matters dealing with incarcerated prisoners with concerns about COVID, they had directives that had to be followed. At one point, it was 100 pages in length. It was very difficult trying to get people to court, even remotely, people transported. It was a difficult time. I remained accountable. Many of the judges during COVID remained in the same assignment for a year because we were all dealing with conditions, some of them are unique to the different counties, difficulties there. So that I remained there. And then I moved to Lamoille, the next from fall of 21 to summer of 22, Lamoille. There I was doing criminal and all the aspects of family. So including also the delinquency, the GINS matters, parentage and domestic. That whole time in AO 47, I would ask. For 2.5 years, I wore a mask every day to court. I tried to get to court and be there in person rather than just doing remotely whenever I could. Some of the remote technology now we have was newer. We were trying to adjust to it. So when I was in Lamoille for that year, I was fortunate in that we had airflow studies for the various courtrooms. It had the best airflow of about any county. So I was able to do 4 criminal trials during the height of COVID, with jurors separated 6 feet away. And 2 of those are very challenging. I had a 2-day trial and a 4-day trial. They were multi-count sexual assault matters with detained defendants. But we were able to get those done despite some of the backlog and issues we were having. So then from there, from Lamoille, I went to Washington County in Barry. There I was in the domestic, all aspects of it, relief from abuse, GINS dockets, delinquency cases, and the parentage and divorce. So I was doing that for a year. Then I was moved to Washington County because of the concentration in Chittenden County. The next rotation was actually in Chittenden County. I went to the criminal division. I think part of that was because that courthouse was very much in flux. They normally have 6 judges there. There's a period they're going to be down at least 2 or so with some of the newer judges coming in. And what, in part, when I was in the criminal division, there were 3 of us there. I spent 40% of my time in the family division. The reason being they were short on judges and needed the coverage. So I think when you look at some of the responses I got, like the backbeat months or so through their sentiment, I saw about 30% of those people who had practiced in the family division. Some of those may come from there, because largely, because what's happened after that, since September of 23, I've been in the 24, excuse me, I've been in the Washington Criminal Division. There's a certain set of attorneys I tend to see. Judge Schoonover has the family division. I'm not doing much family work at this point. So glad to see there were some of those responses. I gave you a flavor. There were some comments I saw. I looked at the breakdown of what the primary practice was. I looked about 2/3 of them were family practitioners. I was glad as you looked at those comments, you were able to get some input from that side of where I have presided, even though I've been in the criminal assignment. So I had that. I was glad you had Judge Bear here last week, and I realized he made an error in addressing his letter to Contos.
Yep.
I say that because I think he's given me some precedent for a couple of things I want to point out. In page 2 of my submission, I talked about it in doing all civil and criminal since my last appointment. Civil and family. I meant to say criminal and family. I've only done a couple civil things in the last 6 years, including the small claims court matter that Judge Judicial had a conflict of interest in. The other thing I'll note, that as long as I'm owning up to some of that, I mean, look at my writing samples, you're going to see one of the cases from the family division I indicated was the Patridge v. Martin's family on my index there. And actually, there was a matter of Bogey v. Gates I substituted in. I thought it was a better reflection of some of the issues I was trying to demonstrate. I apologize if there's any confusion that might have been caused by that. One other thing I want you to note when you look at my decisions, there was one comment or so. I'm happy to address all these comments about timeliness of some of my decisions. You look at the date in some of those and they seem far from the hearing. It's because I printed them out from Word copies. I keep Word copies of all my significant decisions. In the family division, I keep an index I have 120 of them of different topics. When I print those out on the Word version, the version that has my date has an automatic date and time stamp. So those are not the dates and times they were issued and when I printed them out for your consideration. So please give me that indulgence. I want to talk a little bit about the way I approach my work. I thoroughly prepare for court hearings. I review the files. Sometimes I will see anticipated legal issues with issues that have been raised. I'll do some research on those sometimes to be ready. What you heard me talk, if you read my questionnaire response about Odyssey and some difficulties enterprise our electronic court system, it's difficult to get a single schedule. I like to go into a hearing to be prepared with the schedule. I know the parties, I know the cases, I know the type of cases. I can see the back history. I might want to see the criminal history of the defendant if it's important, depending on the kind of hearing. I go in and I create those assignments. Yesterday, I had 3.5 hours it was a status conference. I had 13 cases, 13 defendants. There probably were 50 matters. And I prepared an outline for my use in preparation for that. It's 9 or 10 pages. And I do that in part, why? So I can follow the track of the hearing. As I'm getting ahead or behind, I know what's coming. I can focus the attorneys when I'm there. I can focus if there's discussion about the prior history, I can point right to it and talk about them. It can give me focus to what needs to be done in the case. So preparation is important. Careful preparation, though, is not prejudging. That's the other thing that I carry with me. I remain attentive and actively. I might have all us judges who prepare. You might have a perception of what you think might happen or what you should be ruling, looking at the information coming in. You need to be prepared, but listen to the information coming in. That's an important thing. So what I do is I will, if I had some impressions, I'm looking for information that may confirm some of those thoughts, but more importantly, I look for things that may make me look at it differently. What may have caused any impressions I had to be incorrect. Things that may differ from that. Many times I'll go into a hearing with an idea, for my preparation, how it may be what should be the result. I do something quite different, right? I've had times when I've heard the last argument, the last witness, and it's completely changed the view in an important way. We tell juries that. We tell them, don't talk about the case until all the evidence is in. We have to do it in a sequence. And sometimes the last thing you hear may be among the most important. So I try to keep that open mind. Judge Battles talked about procedural fairness as tools. I follow those. I think you might have had Judge Bear talk about those. They're very important in the way I approach cases and litigants. Describing how the hearing will be held, treating people with respect. I use a lot of eye contact, particularly with defendants and things. Everyone gets to be heard. I try to explain my decisions and why, and whether it's written or oral. That can be challenging, and sometimes I tend to be thorough to explain it to make sure people understand what I'm doing and why. And my audience is not just the attorneys, but the order judge. I have the parties, I may have the victim. I want them to understand what I consider and why. That's important to me. I will, one of the comments talked about me, I'm citing cases and different things. Sometimes I'll have notebooks and outlines where if I'm sometimes referencing the law I'm using, I'll make the citations so it's clear that I'm not just doing this on my own accord, and it makes proper record for appeal or review. It's important that judges apply the law correctly. and I update some of those tools I have in front of me. The important thing I think about a lot is implicit bias, and I actively use tools to try to avoid that. What I try to do when I make my decisions, I look, am I using objective factors, not including assumptions? Those are some of the things that can inject bias, those unconscious biases about characteristics of people. Some of the tools I use, if I'm using things, I may switch roles or players or something. An example would be if I have a parentage action, may have a mother and father, ask me to rule in favor of one. I switch the gender of the parties with the same facts and say, let me be looking at this any differently. If they were in the other roles, it helps give me a check. There may be other different things I will look at. There can be so many things that can inject bias. It can be, age of people, it could be social economic class, whatever it may be. Maybe you might have someone with a trauma background that has certain challenges, and I try to look at, am I making assumptions about those? Am I looking, am I drawing, am I not listening to what is in front of me versus trying to impart on them things that may be stereotypes? There's an assault between two partners, intimate partners, say. I've been avoiding, this is not, I may have had an intoxicated partner assault someone, and that's a different case. I don't want to start to imagine those assumptions on the people in front of me. Each case is unique. I was trying to see what those unique matters are. The other thing, sometimes I'll have to you can take a break sometimes. Sometimes I'll write decisions. There is the load. I do a fair amount orally. If I said it's a really difficult case, writing decisions, what I can do, it requires a more reflective and clear decisional narrative. We don't, as judges, we don't have ideally, if we, in the vacuum, we might write everything out. Be really careful, precise, and time doesn't allow that. But some decisions, some situations require that type of reflection and clarity. The other thing I do in part is trying to be able to avoid biases. I try to learn and think about people who are different than me. I have people coming in with many challenges and background, and they're in front of me. I hear their challenges and different things. Part of what I'm trying to do is when I'm there, I'm the judge. I can see people in front of me. It's me and them. And what I try to do is think in terms of more than we. We all have commonalities. I need to not be separating, looking at those differences, but have that open mind. So those are some of the approaches I use. And I've always prepared, and so I try to be prepared. I believe I'm competent. I try to avoid arrogance or overly smug self-assurance. I retain humility in that I know I have the capacity to get it wrong. And so sometimes that final reflection can be, if I'm feeling it's super clear, or have I really given sufficient consideration of the opposing point of view. So with that, it's a matter of being able to forward, prepare, having the confidence to make the decision, which I do ultimately, but trying to use the best process I can. There was some talk about that with difficult decisions. Part of what I do, it took the other aspect about this job, which took me a year or so to realize, is part of the job of a judge is to make the best decision we can with the information that we are allowed to consider. Remember, as judges, we have to take some of the information presented to us. There are limits on our, but we can't do independent research, go to the scene or read out the stuff. Partly the parties also have the right to appeal. It has to be clear what information the judge is deciding and using in making that decision. And it's unfair to any party if the judge is reaching out to other things. I can't get overly with two self-represented litigants. I can't go drill down and question one in favor of another. So that's a difficult part of the job that we all carry. Let's see, I reviewed the surveys and would welcome any input. I was pleased to see some of the surveys reflected views of me having on issues of lack of bias, competence, and fairness. I work hard to achieve those. There were some comments that had more performance improvements, one might say criticisms. I've carefully reviewed these. I've reflected on some of the things about those. It's difficult, of course, to respond to anonymous comments. We don't know the exact situation. There may be a particular hearing or something arose out of. The role for me is not trying to figure out are they objectively true or sincere. It's really not my focus. The perceptions I create are important, and I recognize that. I'm a figurehead of, for the judge in my court. So the perceptions are important on their own court. I can strive to make improvements. I've reflected on the comments and that's it. But that's really, I think, I reviewed them sort of by topic, have information I would like to have you consider. But right now I don't want to take up some of your precious time. I'm glad you have questions from you all. Thank you all for your consideration so far.
Thank you so much. Would you like to get us started?
Sure. So I try to be perceptive. I notice you're left-handed, as is Representative Arsenault, as is Senator Collmore. So we're all southpaws.
I hope you wouldn't hold that again.
Not in the least, no. It can be challenging. Doesn't matter. But I can remember in school being whacked on the hand that kept me to use the other, and it just didn't work, obviously, because I'm still
And you
left-handed.
would write like this, so you here.
Yeah.
Pencil.
Spiral bound.
So at any rate, in the supporting statement that you
Yeah.
wrote, I did also find it, and I'll use the word heartening to recognize that you moved when Governor Shumlin appointed you and kind of said, by the way, with all due respect to Senators Gulick and Representative Arsenault, there are a lot of us that feel, there's 6 of us that aren't from Chittenden County is what I'm trying to say here. So very ably represented to my right by Senator Gulick and to my left by the chair. But I thought that was pretty good that you were willing to move from Burlington to Montpelier in order to become a judge to lessen the kind
It
of,
wasn't, it wasn't just my decision to have a life partner.
okay,
And
fair enough.
we support each other.
Yeah.
And we knew that we'd be giving up things. We had been in Chittenden County 29 years.
Yeah.
At that point. I went to school in Middlebury. After I graduated, I was in Burlington
Yep.
for 3 years. Met my wife in that process. I was in Wisconsin for law school, came back to Vermont. So really since 18, I've been in Vermont, but Chittenden County, 29 years.
So one of your writing samples concerned the order regarding animal forfeiture. And I was intrigued by the story of the dog Galaxy
Yeah.
and its owner. Your ruling regarding the abuse of Galaxy resonated with me. I've got 5 dogs. And I wonder if you know what happened to Galaxy after the order placed him in the city of Montpelier's jurisdiction.
Well, I'll say, one thing, there was an appeal of that. And the day this went out, that got confirmed by my decision by the Vermont Supreme Court. There were some issues about whether there was sufficient evidence of cruelty. The facts are made. I decided so. I cited some cases in other jurisdictions. Supreme Court agreed with that. The animals, they get. There's an exception, if I remember, they get forfeited. And so I believe the animal's been forfeited.
Okay.
In that, I haven't looked at that specifically, but the animal cruelty, I'm trying to remember now. The animal's in good care, and that's the animal, there are contracts that with different humane
Humane
centers,
Society, yeah.
and that's where the
Yeah.
animal goes. Now, what happens, part of the reason we try to get those done quickly is because it is contested, there is no decisions, clear and convincing evidence. And there's a bill accumulating, and if the person owns the dog loses, they are responsible
Yeah.
for that bill. So we try to get those on quickly. Sometimes there may be counsel here and they want more time to prepare. The underlying matter is still pending, the criminal charge associated with their counsel, and they are, one reason it hasn't advanced is they have looked for more time to consider it, part of that. And if the attorneys want time for certain discovery and things, I regulate that some. It's a high volume of cases. I think we have like 2,500 cases, and but so that matter's coming forward. But the dog's in good hands.
That's all I was worried about. I didn't really care about the rest of that. I just wanted to know Galaxy.
I had another forfeiture case
Yeah.
in
Okay.
Chittenden County that was equally difficult, and there, people care about their pets.
Yeah,
I mean,
sure do.
there can be issues about treatment, but it's an emotional subject. And all, but there are, limits that the law requires. Sometimes people, just like we have, people that do need to care for children, and at some point, the law has to intervene. It's some.
Good marks on the attorneys was 98% and 100% with the staff, so
Thank you.
well done.
Thank you.
Thank you. I was a high school teacher for many years and classroom management is very important. And I'm just having read a few of the comments. I'm wondering if you could briefly tell us about your courtroom management style and or strategies.
Well, part of it, there's some of the courtroom management, but one thing that, might be the actual hearing, and then there's the management of cases. I think there were comments on both of those. I think when you had Judge Bear, Walsh, talking about some of the comments, I do have, things have improved and all, but when you're looking at those and you see those comments, they painted sort of the world they work within. Judge Walsh talked about the environmental division, some of the courts, and
Yeah,
and Judge Walsh.
I'm talking about like the behaviors in the court,
Behaviors.
that kind of management. Yeah.
I try to be courteous to people. I have had difficult situations where I've controlled people. I've had people removed. I've warned people. I've had difficult types of things. I had one case when I was up in Memorial. It was an arraignment. It was a very high profile case. It was a non-citizen, individual, non-binary, I guess I should say, who was a murder case where this individual had the knife blade was that long. They've been thrust across the thorax, killing them by somebody. Self-defense was the defense. It came in for an arraignment. And a pretty busy courtroom, highly emotional. So that was when I made sure I had ground rules. I told people what I expected before we went to the hearing. And people respected that. I had another matter where it was death resulting from someone supplying fentanyl to someone who overdosed. They ended up being, it was a difficult thing. They were friends, but both had substance abuse problems. One of them got the material, gave it to the other. That becomes a felony. Person was highly emotional. The family was very upset. Highly emotional, such that we got warnings that one person might have made possible threats to the defendant, about the defendant. So we had high security going in. It would, again, they had to control their courtroom. There were some outbursts. To give you an idea of the degree of emotion, one of the family members who was there with a container. The container were the ashes of the decedent. It was the brother of the decedent. That's how high the emotion. So again, I made some comments trying to keep an eye on him. I also have my security staff. I look to do that. I'll use some warnings and things. One thing I'm reflecting. So there were some comments. There are a couple attorneys who are somewhat difficult. I might say persnickety. I try to look for some of those, and I sometimes may be less quick to jump in on some of that in between stuff, not outright arguing with the judge, but some of that subtlety. And I try to keep it focused different ways. Here, I see that the part of that I talk about the perception I make is important. If people feel that they are being somewhat more disrespectful out of line, I'm going to one of my lessons from this is jump in more and be more aware of that. I'm somewhat forgiving. Sometimes when I was growing up, there'd be family dinners, there'd be a lot of raucous time and commotion, but it's a different role. I do feel I do maintain control, but this is going to help me be more aware of that. That's some of the courtroom things that come. There was stuff about some of the flow and management. I can address some of that if you want to know some of the background on that. No, I guess you were looking at the courtroom management.
I was definitely thinking of like the courtroom management, but someone else might have.
Okay, well, that's fine, but that's part of the balance. But I am reflecting on that. I'm trying to be more aware of that. Another matter was a man who had I guess he had a traumatic brain background. He was very, he gave very loud and boisterous. And there was an issue about him getting a new attorney. He thought he should be able to direct his attorney to do everything, including getting 30 years worth of files to defend the case. There was discussion whether or not the appointed attorney would have to do that beyond the scope. So I was trying to explain, he got very loud and angry. There, it was he and this attorney, me and some other people. I tried to respectfully approach him. At one point, I raised my voice a bit to get him catch his attention. Tried to bring down my voice, get him to moderate. He continued to get elevated, and I warned him I needed to complete the hearing, and he could not do that. I warned him that if he continued it, I was going to have him removed from the hearing. It pained me to do it, but I was going to do that. I needed to make these determinations. At that point, as he was getting elevated, he said, Judge, I'm afraid I might do something or lose something that I'm going to regret. And he walked out of the courtroom knowing I was going to do it. So there in real time, you were controlling the courtroom. I had a jury trial with a self-represented litigant who 2 or 3 times had to be removed from the courtroom because of aspects of the court. I was able to at least conform his behavior. Luckily, when the jury was in the room, he kept enough composure. He was until the verdict came in, and then he started to spout out. So I'm aware of that. What I try to be aware of the courtroom. It goes beyond that control. It goes with some of the decorum. I watch as I address somebody how I'm doing it, because someone over there may be taking it differently. So that's part of the control. That's part of the fairness that I want to portray. But I'm going to become more conscious of that. I can be someone soft-spoken or soft-mannered. I'm going to have less of the firm. The firmity. I've been able to accomplish things without having some of that outwardly, but I'm going to be looking to adjust that particularly.
Thank you.
Okay.
Yep, thanks.
Evening, Judge.
Good evening.
So I've got I agree with one of my concerns was how Galaxy was doing, but
Well, as well as I think the 6 other animals and the other one I have, of course, but no, they're for, but they, it's difficult. But they when they go into the care, they're well cared for while the matter's pending.
Yeah.
So.
he had good reviews from the attorneys, but I have one question here
Sure.
regarding one of them. So I'm gonna read it, but I'm visually impaired right now, so. It says, Judge Harris clearly cares deeply about the integrity of the justice system. He unfortunately allows judicial assistants to run the courtroom in an inappropriate manner. The judicial assistants have decided they do not want to take emergency measures up and have demanded that the motion that could have easily accommodated to between oh gosh.
I can help.
Can you? No, basically what they're saying is that, sometimes because you allow others in your courtroom to manage your time, that it affects the amount of time that somebody's incarcerated.
I think some of those comments were particular cured with some things that occurred. This is dealing with the judicial system. And then I have to, as Judge Walsh, Judge Barrett, sort of welcome you into my world a bit to see some of it. There is a context for this. So as I said, it's a busy court. I think for judges assigned to a criminal division, my court operations manager tells me maybe the busiest or second busiest terminal value that we're handling. I have, so I'm one judge. There are 6 full-time prosecutors and basically 6 full-time defense lawyers that we're trying to do. There are 4 public defenders. We have contract counsel. There are 4 of them that had to cover many counts, many ad hocs. In part of the, so that's part of what's going on. Looking at, as we look at these different matters, there's limited times for some of these types of hearings. We devote 6 days a month jury trials, because we have a pretrial conference all day. We have an all-day jury trial, and we make 4 jury trial days open. I have arraignments, every morning, every Thursday, there's 2 days gone there. And what I'm saying is, I'm gonna get into this because there's limited court time for many of these types of things. Every day at 1 o'clock, I have to be available. I'm the only judge to cover the lodging law. Those are people who are arrested overnight, people with arrest warrants brought up. They are people who committed new crimes that maybe I took the call and they're gonna come in and the people walk in. We set 1 o'clock. That's part of my court day. There's a whole issue with, many of them are held, so that gets protracted because there are difficulties with the held people. Those of you on the one committee heard some about that. Representative Oliver, Arnasalt, and Kelly, you all got some insight in that. That cuts another out. So I have limited times. It's an important schedule. So any attorney might, and I'm saying this because you see how it came up. The judicial assistants, let me give you some input on those. So criminal division IM, there's supposed to be 5 judicial assistants. We've been down. I got 4 criminal judicial assistants. At one time, the family division was down 70% of their people leave. So my criminal judicial assistants, these are court clerks, document clerks, are helping out there. They in my courtroom, when they are there, when this all occurs, one of the busiest people in my whole courtroom is the judicial assistant. They have 5 monitors they are doing. One of them described, I feel like I'm in a cockpit. They are controlling all the remote stuff that's going on. Anything we have with jails coming on, they have to listen to make sure everything can be heard. They are having the market. So they're the high task. Recently, I heard they had been, as some of the remote hearings things came on, I think their collective bargaining unit was saying their responsibilities had enhanced. I had one of them tell me that I think they jumped up 2 levels on me as their position was because of the complexity of some of what they are doing. I'm trying to get to see some of the demands of these, you'll see. Some counties where I've been in, some of the judicial assistants have had reasonable accommodations not to go in, not to have to be in the courtroom because of the stress level, but although they're able to perform other jobs. In my written materials, you see some of these frustrations about policy or enterprise system being slow. It doubles down when they are making many entries very quickly during a hearing. We're trying to keep something in court. You heard stuff about trying to get through my day. There's reasons why my day can be chaotic and that's a whole different topic. So we had some of these things where sometimes the attorneys would be coming up and we have a schedule and they're into it, would come up and starting to look to interject. Judge, I want to talk to you about this one hearing. It's not on the schedule. Can we take it up and you can talk about this? What I didn't realize also, my judicial assistants, when they were trying to do all this, make all these entries, some of them to keep me moving just with what was assigned were not even completing it while in the courtroom. They were making shorthand notes. After they get out of the courtroom, they were finishing up at their station. Some of them were staying late. Some of them who have been, I had great, the staff is great. I've been very fortunate where I've been. Some of them were staying late. They were starting to give rumblings of job dissatisfaction, possibly. Those are the pressures on them. Part of what my court operations manager sort of said is we can't be taking those things up. We got to get through things. There's too much going on. And there was discussion about that during 1 or 2 of the hearings that came up, and judicial assistant said, should I be doing this? And some of them, I said, no, there was a short period where this was going on. We had a bench bar. This is the thing about, I run the courtroom. There was a discussion, no hearing. I have all the staff there. And there was discussion about doing this. And my court operations manager said, there's some things I control, and there are opportunities to have those things heard. They can file motions. I get to emergency motions quickly. So she then spoke up on that one. I think that's where some of the comments coming from. She and I we do talk about things, she and I, how to use the resources we have. Maybe some people thought, I should have responded more affirmatively. There's another reason I don't. I had an experience in 2018 dealing with my court staff. I had a judicial assistant who was working, I was in the civil division. I went over, I was supposed to get ex parte requested in the civil division for things right away to get to the judge come in. It may be someone trying to freeze an eviction order, right? You give them more time. It may be someone looking for a temporary injunction. Some of those had not come into me right away. I went to that court staff person, asked, what's going on? Why isn't this happening? I was respectful. She explained why. It was a good reason. I went back to my chambers. 10 minutes later, that judicial assistant came into me. He said, Judge, I wish you'd talk to me about that privately. And I felt as though you were challenging my competence in front of my colleagues. It kind of upset me. I told her, you're right. I shouldn't be doing that. So I'm in a setting like this bench bar. It's not the time I'm going to start debating, and I'm going to take it up later. I indicated that. So it's a team. There are times when I want to do things and I can't because of resources. 3 times when I was in Chittenden County, they had a judicial assistant call in sick. They lacked the other staff as running courtrooms. And I would commute over there. This is when I was commuting from Washington County. I got there and my day was canceled because there was no judicial assistant to go in the room. It wasn't my right to go and grab one as they come with me. At another hearing there in the family division, same thing occurred. I talked to both of the court operations managers and we found someone to cover it. So I don't control every aspect of my courtroom. They aren't running it. When I had these matters, and we are now, some of these ones that have come up, Judge, can we take this up? If I have time, I try to do it. And the other pressure I have is when those judicial assistants are very busy. They may be busier than heck. And if I ask her, can you do this? I'm the judge. What are they going to say? Yes, of course. And they get further behind. So I have a team, and I'm part of that team, and part of it I have. And so I don't think when I have things that are important, we get them done. If I have someone held with bail that wasn't there, I'm looking for a cop next hearing. I'm aware of the need to move through cases. As far as getting some of the cases resolved, there are reasons that's challenging, that's maybe a different line of comments than what we'll do right now. But that's part of where I think got some of the context for that. We are very much aware of trying to get everything, the important things done, things that will give people important next hearings. But there are a lot of people looking for a lot of hearings, of course.
Understand. Thank you.
No questions, thank you.
It's getting late, so I'm a little hesitant to ask you this question because, but hopefully we can keep it fairly concise. I was fascinated by the case that you included about essentially the 13th Amendment case. Yeah, and we have over the last few years actually done some work on the contractor registry and contractor issues because, as you probably know, it's a big complaint of, it's a consumer protection complaint a lot in Vermont is contractors who bail on the work that they're supposed to be doing. And my reading of this case is that the statute, which I checked and has not been changed since
There's a bill to change it.
there is a bill? Okay, I didn't check all the bills.
Take
but-
out that provision that was the focus of it.
Is it a House bill? Maybe it's
I forget.
in your committee.
It's up for a vote in Senate hearing first.
Oh, it's a Senate bill. It is a Senate bill. Oh, good thing, Michelle. Because I was like, this hasn't been changed yet. We should change this. But it's fascinating because what is the recourse? I mean, I understood your argument. I think that
It's not my argument. It's
or-
not Supreme Court.
well, yes, exactly. I mean, I understood the argument. It makes sense. I hadn't thought about it in that sort of context that you're sort of compelling somebody to work. But at the same time, if they don't have the money to repay you, is there recourse for somebody
There
who?
is, I mean, and I don't, it's actually a very narrow decision, just dealing with And I tried to make it that the issue was put to me in a motion, so I needed to decide it. I looked at it carefully. I had a ballpark, someone on that writing was from a ballpark, really reviewed the work and looking at the court. They're the ones I wrote myself. But she looked hard and the law was old from the US Supreme Court. We looked all over to see if it had been applied to different contexts. There's somewhat stilted language in some of those, but I found it was clear. And this is the involuntary servitude attached to some of the things particularly that happened in Jim Crow, those types of things. But part of it is if just part of what the jury's going to hear is that someone, didn't perform services and that becomes a sub part of the crime. You can't get an inference of the fraud through that type of thing. That's, what it is. You take that out, there are other ways you can have inferences. Of course, the fraud is looking at the time of inception for these criminal things, not later. But I think there's an attempt to use it as a tool. But there can be things where, so it is actually very narrow. I read the cases 3 or 4 times. I looked at everything that came out of them after them, but I'm not detracted from that. I found this statute, I was surprised because the statute I think had been used in other states. I haven't seen anything else discussed. So I think there are ways. I do know, I hear that, well, it certainly wasn't appealing in the county where I was. I think the AAG's office considered it and but it's very narrow.
It is narrow, but so let me understand what you're saying is that you can still make a claim and prove fraud. It just can't be the sort of punishment can't be that somebody has to be compelled to work.
Well, there wasn't any punishment in that. And just there are different ways. Really what the problem is, the jury could be told that they could have done more.
Yeah.
And the failure to do the work to get out of criminal liability can be coercive, makes them not. Not really the case, paints it.
Yeah.
There wasn't the coercive effect that has to be part of the law. There are many ways that people are charged with crimes. They may do something outside to alleviate. It may result in the state's desire to go forward with it. It may have something that the shoplifting. It may be that they pay back that. The merchant doesn't want to go forward and the state is content. Doesn't mean the jury is going to be told whether or not, hey, you didn't pay it back when you had a chance.
Right.
And we can consider that. So I think I think the bill that we're going to take out that part of the provision, we all continue to look at it. I think there are some decisions we issue, and they are found to be correct. There are many times the laws with us.
Yeah. It's good. It means the checks and balances are working.
Yes, the unfortunate thing, but it's come out early in one sense that people who are subject to that law may have widespread application. Judge Arms adopted the same reasoning.
Yeah.
And some of the other judges were adopting in some of the things before them. And then there can be the expediency to get the law revised, if that's appropriate. But those are things I don't decide. I have to control the laws and
It's our job now. Thank you.
Thanks, Judge. We both have long rides back to Montpelier. So no further questions.
I was gonna address my man. That's the only thing that comes to mind, having sat in the courtroom a lot and comments in the binder. It just seemed like it took us some time to get through some of the hearings, a lot longer than maybe you may have. But it's hard to find fault with someone who's trying to do their best at coming to a right decision.
Well, it's getting rid of that. I'll try. I know it's getting rid of. One, I'm trying to be more concise, but I need to be able to explain my decisions. If for someone saying I don't know about that one that said I went on for a while on the 15-minute thing over that was on that. Not sure. I'm not sure that the litigants in that case felt the same way. But as I said, I have the preparation law. Give you some. So audience, I think, are coming to the status conferences. We have the attorneys come in, and before they get to a final pretrial, we come in and see is the matter going to be resolved. And in my county, It's public defenders, we have blocks, they come in and talk about several cases. They're so busy, if they're here today and say, I want to see you in 30 days, Judge, that one's full. It can be a 2-month wait to get them in, it could be longer. Ideally, if I really want to make sure that all the things that might cover in that, I would schedule light. I might schedule, so at the end, for instance, when I had the 13 cases over 3.5 hours the other day, it was about 15 minutes a case. If I really want to be safe and go seven cases, you can see everyone gets spread out. So there's a little bit of the Goldilocks, not too hot, not too cold. We kind of play the averages. Doesn't mean every particular day it's going to go smoothly. What's part of that docket is a certain level that's unpredictable and chaotic. There are many factors, but that would be cognizant of the time. A common one, and there was a comment about me letting attorneys talk too long or the parties. Many of these people have a public, 95% of the people have a public defender. They aren't paying, but they don't have the means. Really, that's part of why they're indigent. They don't have the means to pay the copay. But it's not only that, it's different than private counsel. They also have challenges. A lot of these people don't have secure housing. They don't have a phone. The phone runs out in minutes. Someone takes their phone. They don't check the email at the library, you know. So what happens many times is they come in for the hearing 2 months later, and assuming they appear, their counsel hasn't spoken to them despite efforts. I also get competing information about mixed calls. So now I have a thing where I'm supposed to talk about the case, and there's the person of their attorney, and I got 2 options. I can say, well, time's running short, see you in 2 months, or I give them the opportunity to talk, and then come back in, and that's gonna move the case. They may have an agreement now they want to do. I may have time, I may not, judgment call. And we're gonna do it. I'm looking at my schedule, trying to figure things out. There can be unforeseen things. Person comes back and they say, I want new counsel now, my attorney's not responding to calls. There's a process with that where I need to work with them and try to explore saving that relationship versus having to have new counsel appointed. There were so many dynamics. There were people appearing remotely, ignorant. We have the whole situation trying to get the correctional facility lined up and getting the person in the room, having people be able to hear. The challenges with some of the remote stuff is quite growing in some ways. So there are many different things like that come up, and sometimes it does get by. I'm trying to get better watching that. If I have someone where I'm going to do something more extended, I'll let someone jump in front. But sometimes I have a change of plea might be, they come with a 3-page document, I might have them come back. So there's always a judgment calls. And sometimes there are some days when it doesn't go smoothly. I think those are the days that people remember, sure, you don't want to have to come back. So it's a challenge. It's the Goldilocks thing of trying to get things done. Not too many, not too few. I think that's part of where that's coming from.
Well, I am the last one, and I think my thoughts have gelled into more of a comment than a question, but
Yeah.
it just, as we know, with all of the judges who come before us, there's going to be a range of, perspectives and characterizations, and one person's unflappable is another person's mismanagement. So that's how I look at all of this. But what I see running pretty consistently through these comments and through even the way that you've presented yourself here to us tonight is a real, you seem to me to be rooted in empathy. And I think that of all the characteristics that I would hope for in a judge, that might be number one. So I really, really appreciate that. And as you've been talking, I've been thinking, I have a 15-year-old son, and I'd love to think in, not going to ask how old you are, but in however many years,
Older than 15.
in however many years, I'd love for him to be before a group of people, talking about his work, his devotion to his job, and have people be saying these kinds of things about him.
I'm glad to see some people acknowledging or having the perception or acknowledging some of the characteristic character and way I approach the judge. So some of that we have trepidation, but it's we don't have the sample size, what it is. So I was pleased to see those, but I also but I also look for those areas of improvement and take those to heart. So we can keep learning and, you know, we aren't gonna go stagnant, but times. And it's a challenging judge, you know, many of the comments you heard about beginning judges, that's real. And, there was talk about the loads on us, what does it look like? I've been at 10 years to be next month, and, I've had about 25 judges move on from it, I think in that time. And many of them, I've talked to them, one of the questions I had is compared to when you started this job, is it more demanding or less demanding? Just about all of them, they'll talk about it being more demanding, if you look at what we're asked to do. But we kind of do that and go in with people, all my colleagues love the job, it's important work that we all do. I went in eyes open, I talked to some judges before I decided to apply, and went in eyes open, but it's a little different when you're in it, but you know, I knew many of us are working outside our original matters. I never did any criminal law before becoming a judge, and I've been doing it for 2.5 years.
Yeah, and I'm encouraged to see that 10 years in, you've got, you detailed some ways that you're taking care of yourself.
Yes,
You know,
those
settings.
things are important.
Yeah.
We've added another grandchild since then.
Oh, congratulations.
Well, thank you very much.
Thank you.
All right, that concludes this evening's agenda. So I will take a motion to adjourn.
Don't move.
Second.
All those in favor?
Aye.
Any opposed? All right, thank you so much, everyone. We are